Продовжуємо засідання. Прошу запросити Певну Ольгу Сергіївну. Доброго дня. Розглядається питання щодо відповідності кандидата на посаду судді Вищого антикорупційного суду Певної Ольги Сергіївни критеріям, передбаченим частиною 4 статті 8 Закону України про Вищий антикорупційний суд. В залі присутні члени Громадської ради міжнародних експертів Роберт Гайд Брухайзен, голова ГРМЄ, Норман.
Translation.
Don't have translation. І...
One, two, three, 1, 2.
Норман Ас дистанційна, Мері Кей Батлер
Norman As online, Mary Butler online, John J. Sullivan, Jessica Locke Thompson, members of the High Qualification Commission Judges of Ukraine, Михайло Погоніс, Ярослав Дух, Михайло Кадисюк, Надія Кабецька, Ігор Кушнір, Руслан Мельник, Андрій Пасічник, Роман Саботаж, Руслан Сидорович, Сергій Чумак, Галина Савчук. You can file a motion for recusal, express your objections and challenge the decisions of the Commission. Will there be any recusals? No recusals. Thank you. The rapporteur on your file will be Mr. Sidorovich. Thank you. So, brief information about our candidate. Pevna Olha Serhiyivna, candidate to the position of HAC judge, by the decision of the High Qualification Commission of Judges of Ukraine of June 2025, the competition was announced to fill in 23 vacant positions of the Anti-Corruption Court and the HAC Appellate Chamber. Within the term, Pevna Olha Serhiyivna applied to the Commission to participate in this competitive selection to get the position of a judge as someone who corresponds to the requirements of Article 7 of the Law of Ukraine on Anti-Corruption Court, and asked for a qualification examination to confirm her ability to administer justice in the respective court. By the decision of the HQCD, 18th of September 2025, Pevna Olha Serhiyivna was admitted to qualification assessment and participation in the selection. By the decision of the Commission of September 2025, a qualification assessment was scheduled within the competition to fill in vacant positions of judges to the HAC and HAC Appellate Chamber. By the decision of the Commission of the 19th of September 2025, a qualification assessment was scheduled and the order of its stages was established. By the decision of the HQCJ of February 2026, the general results of the first stage were approved. Upon the results of the qualification assessment, Pevna Olha Serhiyivna scored 327.75 and was admitted to the second stage of the qualification assessment, study of the dossier and interview. Brief information about the qualification of the candidate: in 2008, the candidate graduated from the National Legal Academy and got full high education in the area of legal sciences. Brief information about professional activities of the candidate: from 2008 to 2009, Pevna Olha Serhiyivna worked as a legal counselor. From 2009 till 2016, worked in different capacities in Kharkiv District Administrative Court and Kharkiv Court of Appeal. By the order of the President of Ukraine of September 2016, she was appointed to the position of Judge of Troitsky District Court of Luhansk region for the period of 5 years. By the decision of the head of the Supreme Court of December 2022, she was seconded to Kyiv District Court of Kharkiv City. She has professional experience as a judge of over 5 years and masters Ukrainian language. That's general information from me, and I'm passing the floor to the chairman. Thank you. It was the basic information about you. Would you like to add something? No, everything is correct. Thank you, Mr. Robert. The floor is yours.
Thank you. I pass the floor to Jessica, who's the rapporteur in your file.
Thank you, Mr. Chairman. Dear Olha Serhiyivna, may I call you this? It's okay. My name is Jessica Lott Thompson. I'm a former prosecutor and lawyer from Canada. You've heard the names of the PCIE members, but I'll indicate who we all are in the room here and introduce us. So on the screen, to your left, you have Mary Butler, who is a prosecutor with the Department of Justice in the United States, and Norman Aas, who is a former prosecutor and lawyer in Estonia. To my far left, John O'Sullivan, here at the table, who is a former judge and former prosecutor, now retired from the United States, and Robert Broekhuysen, who is a former prosecutor and lawyer from the Netherlands, and Justice Gabriel Jodkate-Gradskiene, who is a judge from Lithuania, and I am from Canada. So we will today be asking you some questions about the materials that you have already discussed with us. So we have sent you written questions, and you've had an opportunity to respond, provide detailed answers. So we're going to go through some of those materials. Please feel free at any point to refer to your written answers or to repeat any of the information in your written answers. Some of this may seem repetitive, that you have already answered our questions, but the purpose of asking you again in this oral hearing is for transparency and for the public to understand this process. So I'll begin and just ask, what motivated you to apply for a position as a judge of the High Anti-Corruption Court?
Well, to explain my motivation, which guided me to participate in this selection, these were, first of all, personal motives. I wanted to change that permanent state of uncertainty because I am a judge who is not fulfilling its functions. Secondly, I think it's an absolutely adequate desire to keep growing professionally. And talking about the intention to work at the High Anti-Corruption Court, as for me, that court was established against the backdrop of certain circumstances in our country, so there is huge attention towards its activities, and based on my experience, I think I will be able to work as a Hague judge.
And which aspects of your judicial experience do you consider the most relevant for adjudicating corruption cases? Have you worked on do you have previous experience working on cases related to corruption or other complex financial or economic crimes?
I think that considering the tasks which performs the High Anti-Corruption Court, I had some experience.
I will remind you to please keep your questions brief and concise. There's no need to provide an introduction. If you can move directly into the answer. Thank you.
Okay.
Since I am a judge of a local court of general jurisdiction, and I have been working since 2016, I worked on criminal cases related to corruption, such as meeting. We've resumed the live broadcast. Please,
Ви відповідали чи да?
you were answering, right?
Продовжуйте.
So please
З
continue
моменту, на якому нас перервали, на жаль.
from the moment you
Так, продовжуючи
stopped.
надання пояснень з
To
приводу
continue
тих,
my explanation
справ, які стосувалися
about the
корупційних
cases
злочинів,
I handled that were related to corruption offenses, I was saying that I was considering petitions to provide permission for a special pretrial investigation, and it was about this category of crimes according to Part 3 of Article 263. I was granting permissions. Then there was Part 3 of Article 357 of the Criminal Code.
This is a bit more detailed than is really necessary. I think at this point we have received your written answers, so it's not necessary to repeat all of them. I'd like to talk to you. So you've described that you've had some experience working on cases related to financial crimes. In your experience as a judge, how important is it for you and for the court to receive and to be able to assess completeness of information in the financial declarations of witnesses and other parties before the court? How important is it to receive, to be able to have full declarations? And how does that work when you are assessing financial crimes? How do you, as a judge, deal with the issue of incomplete declarations? And how important is it for there to be complete declarations?
Під час розгляду мною
During
адміністративних
my consideration of administrative offenses related to corruption, and namely untimely submission of failure to submit a declaration on time or failure to submit information about significant changes in status. In my opinion, it's very important to have the full information from the declaration and assess it according to legal requirements and my personal convictions.
So if you were a judge of the High Anti-Corruption Court and you were trying to assess compliance with tax legislation, for example, how would you deal with the issue of an incomplete declaration by a witness, for example, or an accused?
Якщо правильно розумію ваше питання,
If I understand your question correctly, I would have to work with the materials provided by the pretrial investigation authorities to establish whether there was guilt of the accused
Can you
persons.
explain to me the law in Ukraine related to filing incomplete tax declarations?
на сьогоднішній день це закон про запобігання
Currently, it's the law of Ukraine on prevention of corruption, which sets the main requirements and limitations that apply to people during their filling in of declarations. There are explanations from the National Agency for Prevention of Corruption. They are recommendations, but they are used and relied on by the public officials as they fill in the declarations. And if an individual committed a corruption offense, we rely on the Criminal Code of Ukraine and the Code of Criminal Procedure when we consider such cases.
So let's discuss a little bit about your specific finances and yourself. So specifically related to your residence, from 2016 to 2022, you worked as a judge in Troitske, while your only declared residence was an apartment in Pisoshin. Where did you actually live during the years between 2016 and 2022?
Так, все вірно. Я підтверджую, що
Yes, it's correct. I confirm that in my declaration for the period of my activities as a judge, I didn't declare any residential premises that I would live close to my place of work. In the declaration, I indicated the information about my registration, and as I was filling in the declaration, I was guided exclusively by the law on prevention of corruption, as well as explanations from NACP on that topic. And in that case, we may refer to temporary limitation.
In 2016, is it a? You don't need to give the address. Just give me the name of the city. Where did you live?
протягом кожного року я
Every
змінювала
year, throughout every year, I would change from 1 to 3 places of
The
residence.
answer that I require at this time is one word, the name of a location. It can be a town, a city, it can be a village. Please tell me the name, a single word, for the place where you lived in 2016.
на час робочого часу я проживала
During my work time, I was living in Troitske village.
під час роботи.
Okay.
During my
So
work,
your declared residence was in Pisoshin and you were living in Troitske. Did you declare a residence in Troitske?
Мгм.
My understanding from the materials collected by our secretariat is that you have not declared a residence in Troitske during this period from 2016 to 2022. Can you perhaps reflect on the written answers that you've already provided and let me know whether that is new information that you have declared a residence in Troitske?
Я повністю підтверджую ті
I fully confirm the previous explanations I provided by periods, and I can underline once again that I didn't declare this information, and it is allowed by the anti-corruption legislation, considering that during the period of my use of these residential premises, there was no such requirement to declare these premises to reflect where I was living in Troitske. Even though during my working activities, I occupied residential premises in Troitske based on certain conditions. I indicated, if I'm not mistaken, 4 addresses where I lived from time to time
на умовах або сплати
under the conditions of payment of utilities or utilities plus a monthly payment of in the amount of 1,500 hryvnias or 2,500 hryvnias plus utilities. And I used one of the residential.
Any of these residences in Troitske declared? Why were none of those residences in Troitske declared in your asset declarations during the years from 2016 to 2022?
тому що такої вимоги антикорупційної
Because there is no such requirement in the law on prevention of corruption or the explanations from NACP.
я не користувалась більше всього
I didn't use these premises for over than 183 days a year.
навіть
So how many days per week were you working full-time as a judge during those years between 2016 and 2022? And how many days per week would you typically stay in Troitske? Because you were attending court from Monday to Friday, I imagine.
правильно розуміти, 5-денний робочий день.
That's right. We have a 5-day working week, and if we calculate days in a year, excluding the period of vacation or business trip or sick leaves, and if we exclude non-working days, the working time in Troitsky was, if I'm not mistaken, in 2017 to 2022, around 200 days a year, and I used residential premises from so I changed residential premises 1 to 3 times.
Housing and communal services debts in relation to some of the properties in Pisoshin. According to the court records, there are several court orders which were issued between 2017 and 2022 relating to debts for housing and communal services in connection with your apartment that you have declared in Pisoshin. Can you explain some of the reasons for these court cases and why these debts were accumulated?
Так, звичайно.
Yes, of course. There was a requirement from the enterprise Kharkiv heating networks. There was litigation as to the obligations of this enterprise. They didn't provide the proper quality of services or didn't provide the services on time. I submitted the documents and certificates provided by the employee of the enterprise, and upon these results, pre-calculations had to be made, but they were not made, as a result of which the debt accumulated, even though it was not an actual debt, in my opinion, until the case was considered in court. Currently, the case is still considered by Kharkiv district court, and until the decision is there, I think that there is no debt. After the case was submitted and the case has been considered in the court, and from 2023 till today, there is no that I paid for the services because they are being provided and supplied in full, and I provided the documents to the commission, and as to the two other enterprises, the debts were in the amount of 300 hryvnias for gas services, and it was due to the reform of that enterprise.
Many issues that we need to get to, and to please keep your answer as concise as possible. So I'd like to discuss with you in your application to cancel one of those court orders from 2021, from May of 2021. You stated that since the 18th of October, you have been neither a consumer nor a resident of the apartment in Pisoshin, as a reason that was part of your application to cancel that court order, because you stated to the court that you were not actually residing in that, but that is the declared residence in your declaration. Can you please explain this inconsistency? And can you please take into consideration the responsibilities of a judge to be honest to the court?
Я бачила це запитання, воно виникло в громадськості.
Yes, so that issue has been under public scrutiny. I get familiar with the case file because doubts rose, because I didn't state it in my claim. I did not refer to any evidence or documents that could prove the fact that I live in Troitsky, and because of that, I asked for exemption from that. That it wasn't like this. I provided a certificate from my workplace, and one paragraph that I refer to contains the necessary information from the court order, and that paragraph was reformulated in a way that it no longer reflects the actual circumstances. So certificate from my workplace was submitted by me in order to resume my right to file my claim.
I do have a copy of the court decision here. If you I'm sorry, there's no translation.
It was a technical issue. I didn't hear you. The interpreter didn't hear anyone. So now we are back.
Now we have. So I can provide you, if it's helpful, I can provide you a copy of this court decision where there is mention where you state that you're not a resident of the apartment in Pisoshin, which is the apartment that you listed in your declaration, if that is helpful to refresh your memory.
Дякую. Я
Thank you.
ознайомилась з постановою цього.
So I got familiar with the court decision, and beyond that, I submitted photo copy of the court order in the court in the case that is in the Unified Register of Court Decisions. And beyond that, I also provided other case files that prove that the appellate court has indicated incorrectly the factual circumstances. I did not indicate that that fact. I did not indicate that I only lived in Troitsky, and that's why I needed to be exempted from the debt. This is not true. And therefore, I believe that I was compliant with the law conscientiously and using the facts that were available, and I submitted those facts to the court from the very beginning in my claim.
To a new topic because we're very short on time and we've had some technical breaks. In 2019, your declared income was approximately 95,000 hryvnia, and you had 2 minor children. This is correct from your materials? Nodding yes. According to your declaration, your savings increased by about 12 or 13,000 hryvnia during that year in 2019. And then after deducting that increase in savings, that leaves about 82,000 hryvnia for your living expenses for 2019, which would correspond to approximately 2,290 hryvnia per month. And so can you please explain how living as a judge with 2 children and making this travel on a weekly basis between these 2 cities, which are 200 or more kilometers apart, how did you actually cover the living expenses for yourself and your 2 children for a month with only the amount of 2,290 hryvnia? And did you receive any additional financial support from any other sources?
Джесіка, дякую за запитання.
Thank you for your question, Jessica. So, translation regarding the sums was imprecise, and I will try to explain the situation.
Perhaps the sums? So,
Зрозуміла ваше питання.
Okay.
Ви ж надавали
please proceed.
запити, так.
So questions are clear.
Декларацію за 19 рік я також
And I also submitted my declaration for 2019. So in 2018, I had my second child.
Жовтня місяця я перебувала
And from October, I was on childcare leave. In 2019,
повністю цей рік проживала за адресою реєстрації.
lived at my address of registration. So I did not use any premises in Troitsky. I lived with my children at my address of registration, registered address. Regarding my expenses, they included, that is, I declared 95,000 hryvnia, 95,000 plus, and you stated the factual subsistence minimum, even though we have minimum subsistence living standard under the law. So in 2019, I had my judicial remuneration. I also had business trips and I was on childcare leave. I received my remuneration. And I also received the child support under the law. How I managed to accumulate 12,000 hryvnias. So the duty to the parental duty was maintained by me before the marriage and after the divorce. My former husband takes part in caring for our children. He covers clothing, some other things, except housing expenses. And 12,000 hryvnias per year as savings is a small sum. Therefore, I believe that they were within the limits of my income.
Please explain, you've mentioned that receiving some child support from your former husband. Can you please provide details about this child support in more detail? Did you receive cash? You received clothing, some support for housing? Can you please explain why you have not provided any declaration for the receipt of child support, which it appears must be substantial for you to have maintained a normal living standard of a judge with the subsistence minimum set by the law? I think we can all recognize is not the normal middle-class lifestyle of typically a judge. Can you please explain more about the child support you received and why you did not declare it?
Щодо незазначення відповідно.
So regarding my failure to declare child support from my husband, I would like to say that back then it was not alimony as decided by the court. The anti-corruption law requires us to indicate the alimony as per the court decision. It was a voluntary decision on the part of my husband. We are on friendly terms, we have normal relationship, and he participates in the upbringing of our children to the measure where he finds it possible. So he has never given me money. He could buy things at my request. I would say that children needed footwear, clothing, or some extracurricular activities. They needed medical care. And I would request him to help me whenever I was tight on a tight budget. 7,000 per month it was.
So this child support, my understanding of the law in Ukraine is that if judges received such monetary support, it can potentially be a gift, or at minimum, it must be declared under the law. Can you please explain why this was not declared?
Такий ж обов'язок, як і мене, як матір,
So
утримувати своїх дітей.
it is my mother's duty to maintain my children. It is not a gift, or nor is it alimony. So it can neither be attributed to a gift nor to the alimony.
Another area. There is an issue related to some training that you attended in September of 2017. I understand that you have told us that you attended in-person training at the National School of Judges in Kharkiv in September of 2017 for 4 days, for a duration of approximately 40 hours, and that you traveled to Kharkiv from Troitske and that you attended this training in person. However, during the period while you were in Kharkiv, there were 8 court decisions issued under your name in the Unified State Register of Court Decisions on the 4th of September. Can you please clarify where you are physically located and how those decisions were signed and submitted to the register?
Так, по-перше, дійсно.
Yes. So indeed, I confirm that those decisions were signed by me on September 4th.
Але вони були треба розрізняти, на мій погляд.
But we need to distinguish between the signature of a court decision. All those court decisions had been signed by me earlier, and they had been sent by me to the Register of Court Decisions.
In that case, and this will conclude because we're running out of time. Who actually performed the technical submission of those decisions? Because were court staff given permission to submit them for you, or did you submit them yourself on September 4th?
Я скорочу, не буду там вдаватися в подробиці.
So I will not go into details. So that concrete decision was sent by me to the register. Day 1 of the training, I warned the director of the regional department of the National School of Judges of all the circumstances that that practice was admissible. So I finished my work, and when I arrived to Kharkiv, I used the transportation, and I either arrived in the evening of September 4th or in the morning, September 5th. I don't remember the exact time, but on September 4th, I sent that decision from the work commission. I confirm that.
That concludes my questions. Perhaps other members of the PCIE may have some questions.
Mary Norman on the screen? No? Back to you, Mr. Chair.
Дякую, пане Руслане.
Thank you, Ruslan. Over to you. Thank you.
Пані Ольга, декілька запитань.
Olha,
Все ж
a
таки,
couple of
давайте
questions.
ми дещо спробуємо додатково
Let us try and clarify
ваші судові справи з
your
постачальниками комунальних послуг.
exchange with the utility
У вас сумарно
company. So
це 19-й, 12-й, 17-й,
for
20-й,
2019, 17, 19, 20, 20, 21, and 2023,
Значить, 23-му році було
In
відкрито
2023, a new case was opened
теплові мережі в сумі 99 тисяч.
to recover a debt, 99,000. Could you please clear up
помилкове безпідставне пред'явлення одного
the
позову або однієї заяви на видачу
erroneous claim,
пояснити помилкою, інколи так
erroneous court order? Sometimes mistakes happen,
професійний правник, суддя,
but you are, as a professional lawyer and a judge, after identifying that circumstance, could handle it. But I don't understand why these claims are so multiple on the part of the communal services. Why has it lasted for so long? I will try to explain.
У 2010 році
In 2010, it was the first claimed first court order to collect the debt for utilities on the part of that communal service, and that claim was challenged by me because heating services hadn't been provided. The claim was overruled. The order was overruled. Then every 3 years, the legal department of the company collects debts and sends the order. This is their simplified procedure. But regarding the dispute that we have had until now, yes, indeed. So the case is ongoing. So what I did was I turned to the utilities service company. Having the documents regarding the installation, or that is, the documents proving the failure to provide services, in that case, water distribution, water supply, because those services were not provided or were provided with a low quality. I turned to the company in order to indicate that circumstance, and I asked them to give me the names of whoever received my claim. They pretended that they had kept my request, but they didn't do it. They did not pass me any surnames. But you, as a judge, you know that there are different ways of protection of your civil rights, recovery of a violated right, because this has been a lasting case. I agree with you as a lawyer, but because I know how services are provided, how debts are collected. Well, in fact, this is quite a troublesome story. So when I start paying for my utilities, it transforms into a debt. So we're concerned by the regular character of this problem. So when in 2023 I took action, the company uses a simplified procedure. Yeah, they try to look for workarounds. So for 3 times we underwent such procedures, and when I talked to the legal department, we agreed that they would file a claim and we would proceed like this. After that, so we agreed that they would cancel their claim, and then I would recover my debt.
Порозумілося.
Through a dialogue, we managed to find
Тобто,
common
3
ground.
роки від сьогодні, з
And
2023 року по сьогодні,
from
заборгованості
2023 until
підприємству
today,
немає. Є
I'm
спільного
not indebted
виплати,
to this company.
нарахування, вибачте,
За
за той
останні
період.
3 роки
I pay my bills regularly,
Заборгованості немає.
немає.
and there is
А за
no debt
попередні-
on my part.
Попередньо розглядається
And regarding the previous years,
Гаразд.
the claims are in the court. And how about statutory
А я
limits?
ж заперечую.
Of course, they're overdue.
Ну, так, власне. Гаразд.
Well, okay.
Наступне питання.
So, next question.
Написали у своїх поясненнях,
You stated in your explanations
міжнародних експертів,
to
на ці
the
запитання
PCIe members
ставилися
to answer
з
the
приводу
questions
деяких аспектів декларування, але я хочу звернути
regarding
увагу,
your tax return and your
звернути
declarations.
увагу
But I would like
на
to
такий момент. Нагадайте,
draw
будь
your
ласка,
attention to the following fact. Could you
в
please
який
remind me
строк, повинна подаватися декларація до Національного агентства
what
з питань соціальної
the deadline is to submit the declaration
31-го.
or the asset
31
declaration?
травня?
May 31st. May 31st?
До 1 квітня.
April 1st.
Ну, це, можливо, пояснює те, чому
It might explain why you believe that you did not violate anything when submitted your declaration on May
Була
30.
надана можливість подати пізніше, у зв'язку з ковідом. Але
So
це була можливість
there was a possibility to submit it later because of COVID in the times of COVID.
А що завадило вам подати декларацію?
But what prevented you to respect the deadline, the usual deadline?
Ще 2019 рік.
За 2019.
So we're talking about 2019.
Ну, зазвичай
Yeah, we're talking about declaration for 2019 that you submitted in 2020. And declarations are submitted until April 1st.
Піддано треба.
Будь ласка.
Inaudible.
Ви подали 30.05.
Це я
So you submitted your declaration on May 30.
Так.
Yeah, correct. May
Перше, ви
30.
зайшли в свій кабінет.
But the first time you logged into your cabinet
А чому не пробували це зробити?
Mm,
Не знаю.
was on May 25th. Why didn't you try to do it in March at least?
маленька дитина заважала. Це єдине пояснення.
It must have been my little child that kept me from doing that on time. I believe that the deadline was longer. Yeah, I mean,
Тому з'ясовується.
anything, things happen.
Документи, які треба було збирати і так далі, це у
And
зв'язку з ковідом могло бути
Sometimes you
складно.
need to collect documents, and because of COVID, it could have been more difficult than usually. But I was trying to understand the reasons. Okay, so formally speaking, there is no violation here. Another thing that I wanted to clarify, PCIe members asked you these questions.
Щодо зобов'язань батька вашої
The questions
дитини
regarding
по відношенню
the duty of your former husband
він ж не
to take care of your child. He's not deprived of his parental rights, is he?
Ну, це питання вашого приватного життя.
Then,
Як
of
ви
course,
це
it's up to you both. It is your private life. But
там, де це
we get back to
І,
declaration
власне,
issues.
Жодних аліментів, жодних виплат,
No alimony,
період
no
декларації
payments
немає.
are stated in your declarations.
Це такі мізерні суми ваш колишній чоловік
Are we talking about
сплачує на утримання
just
дітей, чи якось інакше це
very small sums that your husband paid to you? I will describe it
Ще раз,
like this.
приватне життя ми не
So we are not going into your private life. Article 8 forbids us to do that. We are just talking about financial issues and declarations. So I'll try to answer this appropriately. So, at his own initiative, he is participating in financial maintenance of our child the way and to the extent he thinks necessary. So now the alimony is paid as a mandatory procedure. So we started the process in 2024,
Гаразд.
and it will be
Скажіть, будь ласка,
on my declaration for 2025.
Чи вірно є, що у листопаді
Now,
2023
in
року
November 2023,
ми колишнім чоловіком
you, your husband, your former husband, and your children went
пояснили,
abroad,
що це був
correct?
подарунок
And you explained that it was a gift to your elder child, gift from your former husband. It was our gift. Okay. What kind of trip was it? And how much did it cost you? I indicated that in that period we lived together for some time. My ex-husband was a serviceman. Now he is dismissed from the military service on lawful grounds.
наші розпочали.
Тому він не буду подробиці підставте.
So I'm not going into details. It was his proposal to go abroad. It's not my question. I'm asking a different question. So let me just remember. 60,000 hryvnia for 4 people. I took part in this trip. What I covered in this trip? I covered travel, round trip tickets. I covered round trip tickets, and then the cash that we spent there was covered by him, and I paid for the tickets. Why am I asking this? You must understand what goes into this. In 2019, you get a divorce. In 2018, you have your second child, and its father is your former husband. In 2021, your former husband violates traffic rules, driving a vehicle that belongs to you, and that is indicated in your declaration. In 2021, a bit later, a protocol on traffic rules violations is made, and you challenge this claim. He challenges this because you were traveling by train at that moment and you couldn't have violated this. The violation occurred on the part of your former husband, and the question is simple. We are left with the impression that after you got a divorce, your relationship remained more or less, and we are not, yet again, we're not interested in your private life details. We're interested in your property aspect. So your husband uses your vehicle on multiple occasions. You travel with him. He doesn't pay you alimony. He pays you something, but you say that the sums are insignificant from 2019 to 2024. And as you know, some people who are supposed to fill out their declarations, sometimes judges, they register their divorce in order to not indicate part of their income. So, do you understand my concern that probably your divorce was done only to exclude your husband and his property and his income from your declaration, and he ceased to be a family member just on paper?
Дивіться, з періоду з 2015 року, з часу розірвання
Starting from 2015, when the marriage was dissolved, up until today, it's been 12 years.
факту користування моїм автомобілем
Over that time,
колишнім чоловіком відбувалося
my ex-husband used my vehicle when I was absent. It was the use of a vehicle for the period when the challenged were in the children were in Kharkiv at the place of registration, and it would last for 1 week approximately when I was working, and it was when one of the protocols was drafted.
Щодо іншої постанови, я в цей
About
час
another ruling,
була в потязі.
at that time I was in a train. Yes, I was on my way to a vacation on my own, so I couldn't drive the vehicle. It was him who kept the vehicle. So these were two
Я
cases.
не заперечу того факту, що він
I do not
мною передавалося йому, але це
deny that I
знову ж таки
transferred the vehicle to him, but
не підпадає під ті рамки вимог
once again, it's not within the requirements of the anti-corruption legislation. I was not obliged to declare him as a user. Moreover, it's him who would have to declare it in his declarations. Well, his declarations, it's his problems. We are assessing you as to
приховувань з мого боку,
some concealments on my behalf. If we look at his social behavior, his belongings, we can assess it, and I would say that any concealment of property wouldn't correspond to my values. The fact that we communicate, first of all, about children is there, but I never had questions as to how he educates the children. The children love him very much. We always had financial issues, and it's hard for us to communicate on financial topics. But I would like to underline that within 11 years, the fact that we've had communication within those periods, it doesn't prove our de facto family relations. We don't have common household. We do not buy joint property. In our everyday life, we do not spend time together except for those cases. All right, it will be the last question from me. I would like to understand, your ex-husband only used your property during those 2 times, and there were no other cases of use of your vehicle? No, there were other cases. When I was in Troitsk and when the children were with him, but the period of use of the vehicle was not too long. It's clear. Thank you. No other questions from me, Mr. Chairman. Maybe other colleagues have the questions. Yes, please.
Член комісії Мельник.
Melnik, Commission member. My question will be related to the information in several declarations.
Так. В деклараціях ви зазначаєте
In your declarations, you indicate
інформацію щодо грошового активу,
information
і
about
водночас
financial
дорівнює по
assets,
вартості
which
сумі
is equal
правочину, а саме
to
які
the
стосуються
sum
транспортного засобу.
of
Про що
the
йдеться?
purchase of a vehicle. What is it about? It's about a vehicle.
Можу пояснити?
Да,
I
поясніть,
can
бо,
explain. Yes,
виглядає,
please do
воно
explain because
неочевидно. Бо
it
декілька
looks
декларацій містять одну ту саму
strange.
інформацію. Коли
Several
потрібно
declarations
що
contain
за
the
автомобіль
same
було
information.
придбано,
What kind of deed
однозначно
was it? What kind of vehicle was
країну
bought?
Чехію
And why do you indicate
паспорт.
the Czech Republic? Please explain it.
У 2022
In
році
2022,
а,
Oh, she's back. Oh, yes.
можу продовжити?
can I continue?
У 2022 році
Then in 2022,
було надано право громадянам України за
Ukrainian citizens
посадкою
were
розмитнення
given a right to buy vehicles in the Czech Republic with zero customs rate, and that's why I went to Prague and bought a vehicle there.
Приїхавши до України з метою
When
реєстрації,
I came to Ukraine to register that vehicle in my name,
відповідно поставив на облік.
I
Через деякий час автомобіль
registered it, and after some time,
неполадки. Я звернулася до сервісу Toyota.
troubles appeared with that vehicle. I came to the service center, Toyota Service Center, to repair it, but I decided to return the vehicle because the repairs would cost half a value of the vehicle. It was not a rational thing to do. It was not up for use, so I decided to purchase it and to sell it, and so the agreement, sales and purchase agreement for the vehicle was cancelled, dissolved, and that's how I returned.
Про які періоди йдеться?
What kind of period are you talking about? It was May, end of May. So I bought it on the 1st of June, if I'm not mistaken. I came to Ukraine 2022. Yes, it happened in 2022. We're talking about the period of 2 months overall. So we dissolved the contract, and the sum was returned to me.
Автомобіль був повернутий на авторинку, як і всі документи.
And the vehicle was returned to the vehicle market. But it wasn't possible to cancel the registration of a vehicle after the termination of the contract in 2022. What kind of vehicle are you talking about? Toyota. I'm only talking about this car because there was lack of understanding about this vehicle in the declarations. So I contacted NACP to get explanations, and they told me, and actually their official explanations state the same, that as long as I am the owner and the vehicle is registered in my name, I have to declare it in the sections 6, 12, and 14. So that's why I mentioned that vehicle in 3 sections until the moment I could cancel the registration of that vehicle. So basically, my financial state didn't change. It was not the sum which changed my financial state in 2022. It's clear, everything seems to be logical up till the moment when we look at the declaration for 2023. In your assets section, you state that it's cash. sum in cash. And in the information about the institutions you have open accounts you indicate that check company. So if you return to the money in 2022, why do you keep indicating these sums that are related to the check firm? I thought that if this property is registered in my name as the owner, I had to reflect to show the movement of these funds. That's why it's reflected in two sections of the declaration. That's it. They are not kept in Czech Republic. It's your personal position, or did you get such a consultation from the NACP that you should indicate these funds in 2023? Did you indicate it in 2024? Yes. And in 2024, you indicate that these funds do not belong to you, but are loaned to that Czech company. Could you just explain the logic? You mention a cash which belongs to another legal entity. If the cash is returned, why do you indicate in three consecutive declarations the company, the legal entity? What's the capacity of this legal entity in the declaration? You clarified everything. The deed was terminated. It was upon mutual agreement, and formally the vehicle had to be returned, but is still registered in your name because you cannot be registered in Ukraine, but you were returned the funds, and the Czech company doesn't have any claims as to that, or is something happening with the funds, any other liabilities? No other liabilities starting from August 2022. We haven't been in touch. I indicate this legal entity. I am just asking about the section about your assets. Let's sum up. If everything ended in 2022, the whole information provided in the declaration for 2022 was relevant only to the 2022. And in all the subsequent declarations, this information wasn't necessary because we get the impression that these funds still belong to that company, or you gave this sum as a loan. So either you have to delete this information and make it up to date, or maybe you should apply for another written consultation from NACP. Thank you. I will take this into account. I would like to ask a few more questions. Was your husband involved in a traffic accident? Yes, he was. When did the proceedings start? If I'm not mistaken, it was in 2009. And what was the final decision? There was no final decision up till today. I checked the register, and a consideration is planned. And very briefly, without personal data, could you please explain what was the point? Yes, it was a traffic accident which happened at the unregulated crossroads involving two cars. A pedestrian was injured. Did someone die? No, but there was heavy bodily injuries. And was there a claim filed against your husband? Yes, as far as I know, yes. And the material damage is significant. To be honest, we stopped discussing this topic 3 years ago, approximately. I was no longer interested. I was a witness in that case. but it's been 5 years approximately that I was not called to testify, so I cannot give the exact sum of damages. As far as I understand, it was the damage of the other vehicle that had to be compensated, but as to bodily injuries of the witnesses, they didn't apply for compensation, as far as I remember. But the commission got a file stating that your resolution of marriage was related to the desire to avoid paying compensation because of it. I saw that document and I provided explanations to that civil society organization. Since the case is at the court and there is no verdict in that matter, in my opinion, it's too soon to make such a conclusion. Moreover, he incurs personal liability. During your dissolution of marriage, did you separate the property? No. Thank you. How many court decisions did you make over your judicial career? Well, I didn't calculate. In most of the cases, I was investigative judge. I just didn't see any verdict when I was searching by your surname. Could you remind us whether there were verdicts and when did you consider criminal cases? If I'm not mistaken, in the questionnaire, I indicated, unfortunately, I didn't find a ruling by that number in the register. That's why I'm asking. I didn't find a solution. And as to the article 110, there is a decision of another court, and it's only one ruling, not a verdict. So I'm asking, and I cannot explain why you cannot find them. As I was getting ready to the interview, I was looked at your practical assignments. I was waiting for this answer. For this question, could you please explain us what is material damage within criminal proceedings under Article 366.2? There is no material damage there. It's a formal composition of a crime, and it was my mistake. In fact, I have 2, 4, 5 other questions about this practical assignment. Do you think that you are ready to consider criminal proceedings of this category? Yes. Yes, thank you. No other questions? Yes, please. Good afternoon. I would like to clarify. I was reading another case and it maybe confused me. I was not attentive enough. I can recall that. So to continue what Yaroslav said, you applied a sanction which is not provided for by the law. You understand it? Yes. Thank you. No other questions? Dear PCIe members, do you have any other questions?
For me, no.
Mary Norman? No? No.
Раз, добре, дякую. Пані Олі, вам надається можливість звернутися до
All right,
комісії.
you have a chance to clarify something or add something if necessary, please. First of all, I would like to thank everyone for your job. I am sure that your work is important.
Мені б хотілося би сказати, що я намагалася
I would like to say that I tried to dispel all the concerns related to my candidacy, but I would like to say thank you and wish you a good day. Thank you. Thanks to you for your participation in the interview. And we are wrapping up the interview. Technical break.
Сесію завершено.